Hi, my dear subscribers and viewers. Labor codes. Welcome to HR Resonance channel. I am sure by this time you viewed my part 1 video on employers' obligations under labor codes, covering covering two labor codes. Now, further to that, as I mentioned in the part 1 video, view for and wait for second video, that is part 2 video covering other two labor codes. Now, I am trying to disseminate the information and knowledge on other two codes, obligations of the employer under labor codes, under Code on Industrial Relations 220 and Occupational Safety Code. Under this new IR code, the new definition is brought out. Of course, earlier though it was existing in retrenchment definition, but it is called a new definition, that is fixed term of employment, where it is defined. The glaring difference in this is, whenever an employer employs a person on fixed term employment with a written terms of a contract, all facilities like permanent worker doing the same nature of the job relating to the gratuity and other things is available. Employer to be aware about this one, and this can be used very judiciously in project-based, marketing-driven conditions, special circumstances, etc., but not in a regular employment. So this is the one advantage which employer be aware. Another chapter in this is on bipartite committees, wherein works committees are narrated, which is already the existing clause, where there are more than 100 workmen. Committee should be there by notification, etc. One more important provision which employer should be aware is grievance redressal committee. Under the code, where there are more than 20 employees, obligation on the part of the employer to form a grievance committee consisting of equal representatives of employer and employees. Earlier number was 6, now extended to 10, and this will deal with the relating to the day-to-day grievances of the employees in making the industrial relations smooth. This is obligation on the part of the employer. For more details on this video, I have my detailed video you can view in this channel. Next important obligation the employer to be aware is recognition of negotiation union negotiating council. All these years in India, there was a big question mark on the recognition of the union, whom should be the negotiating agent, etc. Now this code has given the answer, and all the formalities, how that will be there, it has given. The employer can go through that one, that way they can use, and accordingly they can negotiate and form and proceed in that. One more important provision one has to keep in mind is, any disciplinary action proceedings must be completed within a period of 90 days from the date of suspension. This is in respect of any disciplinary actions, investigation, domestic inquiry, etc. That way it is all good. Otherwise, earlier it used to prolong. Sometimes there may be misappropriation also in that matter. Rather misappropriation, it was misuse, I can say. So now this is one of the ankusha put on that we must be aware. Next, standing order provisions. So far, hitherto 50 and 100 employees, wherever there application of the standing order, central or state, was existing. Now in this code, it has been amended. Either employer adopt a model standing order or certify old standing order. In each case, information to the certifying officer is required. Preparation and submission for certification of draft standing orders as listed in Schedule 1 by establishment with the 300 workers or more. Now this is the new benchmark, 300 workers and more. This is one of the awareness the employer should have. And also, apart from this, the employer must also know about model standing order and its applicability. Government of India has already brought out two model standing order one for manufacturing, mines, and also for service industry. One can go through that. One more important provision of this IR code, obligations of the employer is strike and lockout, which is part of the business. Strike now includes mass casual leave on any given day by 50% or more workers employed in any industry. So this is one way, good point in case of any such problems arise. And notice period for strike or lockout is defined. Earlier there was a public utility and other industry was there. Now notice period for strike and lockout is provided here, which is good and simple one. In case of layoff, retrenchment and closure provisions also, benchmark establishment to the 300 or more workers to take prior approval of central or state government before layoff or retrenchment or closure. This is the new provision. Earlier we used to call chapter 5 and chapter B with the provisions of less than 100, more than 100 that was there. Now it has been enhanced to 300. So this is employer must be aware and comply whenever it is a need is arising. Then introduction of workers reskilling fund is also another provision wherein the employer to contribute equivalent to 15 days wages in case of retrenchment. How this is going to be used, what is that fund, yet modalities we are awaiting and we have to wait and see. And the employer be aware, streamline the structure of resolution of industrial disputes. Now it is simplified. Removed multiple adjudicating bodies. This is one of the advantage, be aware. And jurisdiction of civil court is barred. Now tribunals have been introduced in that place. Penalties and offences are introduced and penalties are a little stringent and higher and they are enhanced substantially, which is a ankusha for the employer. Be aware about that one and be proactive in compliance. Further, employers should be aware about the unfair labor practice as scheduled in the second schedule on the part of the employer as well as the union. This is very essential knowledge for the employer so that he can adopt good corporate governance. And also in third schedule, what amounts to change in service conditions is also mentioned. What we used to call earlier is section 9A. In case of any change in the service conditions, okay, one has to follow this one, be aware, and compliance has to happen. Further, some of the compliance important points I am bringing to your notice. Form 1, memorandum of settlement arrived at during conciliation or settlement arrived at between the employers and his workers otherwise than in the course of the conciliation proceedings. Form 2, notice of change of service conditions. Form 3, agreement for voluntary arbitration. Form 7, notice of strike to be given by the union. Form 8, notice of lockout given by the employer of an establishment whenever it arrives. Form number 9, notice of intimation of retrenchment closure to be given by the employer to the government under the provisions of Chapter 9 of IR Code and rules made thereunder. Form number 10, application for permission of layoff, continuation of layoff, retrenchment, closure to be given by an employer under the Chapter 10 of the IR Code and the rules made under. These are certain important forms and some other forms are there. You can refer to the code. Well, friends, these are obligations of the employer under the Code on Industrial Relations. Next, my dear friends, the code is the Occupational Safety, Health and Working Conditions Code. I request all the viewers to view this video till the end because I am providing you hefty information in a short note, but the information is more. Therefore, request you to view till the end for your understanding and see it leisurely. And under this obligation, in the first place, employers should know that applicability of code for 10 and more employees across in the first stage. And one more advantage here is one registration and a common license electronically is introduced under all the provisions of the regulatory laws, which you have to wait and see. Already rules have been notified for all that. And a factory definition is also widened. Earlier it was 10 and 20. Now it has been enhanced. So this is one more provision the employer to be aware. Again, under this eligibility of annual leave, under the Factories Act, earlier it was 240 days worked in a calendar year. Now it has been made to 180 days. This is important provision. The employer be aware, accordingly restructure their leave provisions. In the leave, prefix and suffix clauses are introduced. Further, encashment over and above of 30 on demand at the end of the year to be considered. As far as the encashment of annual leave is concerned, so far law was silent. Here we can see the mention, be aware. Then provision of compensatory off also exists. Maintenance of registers and records electronically, and they should be kept at a nearest place, and it should be available to the facilitator. Then Contract Labor Act applicability from 20 to enhanced to 50 or more contract labor. This is one of the announcements to the advantage of the employer. And first time core areas are defined as far as the contract labor management is concerned. Non-core areas are also specified. Be aware. Contractor to have a bank guarantee and furnished contract award. This is a new provision. And contractor to be a license holder. Otherwise, the employer will have a consequence on that. Now, because the contractor is made as an employer. Again, under the code, liability of the principal employer for welfare facilities in respect of contract labor. Earlier, if contractor fails, principal employer can provide and then debit to his account was a provision. But now, onus lies on the principal employer for welfare facilities. This employer to be aware and adhere. Chapter 6 and Clause 24 prescribe various welfare facilities like washing, drinking water, etc. They all continues. Be meticulous on that. Further, notice of commencement and closure of establishment to authorities electronically is also mandatory. Then further, various duties of the employers defined. Among the few is issue of appointment letter as per given format, now which is mandatory. That way it is good and advantage to the employer as far as the employment contract is concerned. Annual health examination. Employees completed 45 years age within 120 days of commencement of the every calendar year. It should be free of cost. Particularly in hazardous industry, it is still more required. This is one of the provision which is a cost factor to the employer, but one way it is good from health point of view. Further, employer to follow safety, occupational safety, health standards. Further, third-party audit for safety is also ensured. Various procedures are mentioned there. That way it is good. That way safety provisions are stringent and it is good for all. Then disposal of waste. Employers' obligations have to be done properly. Duties of designers, manufacturers, importers or suppliers are also being defined. Duties and rights of the employees have been also defined. If there is any imminent danger, the employee can bring to the notice of the employer. And I request all the employer, whenever they devise their employment order or appointment order, please be aware about these duties and rights of the employees. They can make suitable clause and incorporations. Obligations to form safety committees in hazardous industries are more. And reporting of accidents and dangerous occurrences. These are all some of the obligations an employer has to carry. Beware of 125 OT hours in a quarter. Hitherto it was a 50. Few of the states, like including Karnataka, they have already notified 125 OT hours in a quarter. So members are, my subscribers and viewers are requested to refer their respective state rules also in this connection for update. Notice of hours, what we used to call Form 10, or display of the working hours for adult workers, apart from submission to the inspector is also mandatory. This is one of the very important compliance point of view. Still more important provisions for the women, first time, and it is a welcome move. Employment of women 6 a.m. to 7 p.m. for all types of establishments, of all types of work, with stringent safety and dignity provisions for their deployment with their consent. So detailed provisions are mentioned. The employer can further look into that, but this is a one good move for the women employees to work in all sorts of establishments. Of course, keeping into consideration the safety and the training and awareness in that matter. Further, the employees should be all the time be aware of inspector cum facilitator duties and their responsibilities. They should enable and facilitate at the time of inspections whenever that will be there. And further, like all the laws, penalty provisions are also stringently they made. So therefore, the employer to be proactive, comply, and it is most important aspect. Further, all the employers are requested to please make a note, change thresholds under the new codes. Thresholds of the labor laws are changed. Safety committee and safety officer. Factory and safety officer, earlier it was 1000 to reduce to 500. In hazardous process, earlier it was 500, now to 250, obligatory on the part of the employer to have a safety officer. Under the Building and Construction Workers Act, from 500 to 250. Mines, it is 100. Factory canteen, earlier it was 250, now reduced to 200, including contract labor. This is what very, very important the employer to be aware. That way it is cost to the employer. But anyway, now it is a need of the hour. I hope everybody will appreciate that point. Ambulance room in the factory, mines, VOC, it is a 500 only. There is no any change. Lunch and restroom in factories, earlier it was 150. Now it has been come to 50 and above. That way it is good. Cost factor, employer has to create infrastructure for the welfare of the employees. Labor welfare officer, earlier it was 500. Now it has been 250. So that the welfare officer status and function is strengthened and good employment opportunities also. Sarve janaha sukhino bhavantu, because employees' welfare has to be taken, thereby aligning to the goals of the establishment. Further, adequate, suitable, separate shelter, restroom for male, female, and transgender employees in the mine and factory is also prescribed. My dear employer and my dear friends, please be aware, transgender employees is introduced here, so that they are also given equal status and also representation and opportunities to participate in employment and live their life happily. My dear friends, the whole idea of these videos, though it is a hefty subject, they are voluminous. I try to bring in a capsule manner. For quick understanding, I only highlighted, though there are some provisions I know I left that one, but ultimately the whole idea of the videos and the employer and my point of view is compliance, compliance, compliance. For good and better corporate governance, for good employer-employee relations, for sound industrial relations, okay, this compliance of the law at a minimum level will go long way in the long term. Rather, I can say compliance is cheaper than litigation. I repeat, compliance is cheaper than litigation. Compliance is cheaper than litigation. Therefore, my dear friends, be aware and try to be all the time, be compliant and be safe. Further, some of the quick forms, though there are many, form 5, medical examination shall be conducted by qualified medical practitioner. Form 6, notice of accident of dangerous occurrence. Form 7, notice of periods of work. Form 8, register of wages, OT, fine, deduction for damage or loss. Form 9, unified annual return form. Form 10, register of accident and dangerous occurrences. 11, register of leave with wages. Form 13, application for license, renewal license, amendment of license, experience certificate of contract employees, etc., etc. The forms go like that. You as a compliance person go through the code and take appropriate and follow that one. Well, my dear friends, this is the innate gist. As I said in a capsule form, I try to bring to your notice as a basic awareness and to create interest in the labor laws on the employer's obligations under the labor codes in the part 1 and part 2 video. Those who have not come access to part 1 video, I request all of them to go through that one, see the part 1 and don't miss this part 2. My dear friends, if this information is useful to you, I am very happy. My efforts are worthy. Please share this information to maximum to the needy students, practitioners, compliance officers, etc., etc., and also to the employees union and the employers. And don't forget to subscribe to our HR Resonance channel. And based on your observations, I request all of you to please don't forget to post your comments in the comment box of the video. Look for my other further useful videos on innumerable topics. My dear viewers and subscribers, thank you very much for your patient listening and observations. Good day.